Right? So then at the federal court there were 3 appeals again. 2 appeals by Subhashini against the main appeal in which she lost in the Court of Appeal. Secondly is against the appeal in which which the Court of Appeal agreed with us that the arrangement should not be granted. So she appealed against both the main decision of the Court of Appeal, and of course we had our appeal against the arrangement granted by the Court of Appeal. Before you go to the federal court, you have to get leave from the federal court. So in order to get leave, you have to pose some questions. So the main question was, does civil court or Sharia court has exclusive jurisdiction on matters pertaining to that issue between Subhashini and Saravanan? In that nature of cases, which court has exclusive jurisdiction? Now, what the federal court said is, in the majority decision, is yes. Now, to us, that does not answer the question. When one asks which court has exclusive jurisdiction, the answer should be either civil court. If there is any limitation to your answer, you would then say that civil court but provided or whatever. Or if you want to say it's Sharia court, you would say Sharia court but provided, if there is any proviso. But the answer cannot be yes. So that's where I find it difficult to explain the effect of the federal court decision, and that's the very reason we have taken it up to the further again to the federal court for review. Whether it's going to be allowed or not, that is the discretion of the federal court.
If you look at the federal court's decision in the Subhashini case, it's saying that she has, the civil court has jurisdiction, the Sharia court also has jurisdiction. The federal court has said both courts have jurisdiction. This is a completely unsatisfactory decision, all right? And it has left it open as to who is going to decide the case. Now, what if she goes to the civil courts, he goes to the Sharia court, and they come up with different decisions? How are you going to solve that? These are the kinds of issues which are unresolved. And these are the kind of issues which the forum, I believe, was trying to solve. Yeah? So the MP and his complaint that they're not respecting the Sharia court, they're not respecting the Constitution. How are they not respecting the Sharia court? How are they not respecting the Constitution? Are they calling for a destruction of the Sharia court or the destruction of the Constitution? No. They're calling for a clarity and a clarification of the situation as it stands, which is very unsatisfactory. And there's nothing wrong with that. And we have to settle this, because otherwise there will be problems in the future, and there will be these humanitarian issues that you mentioned, where the children and the family are in a state of limbo. So the criticisms against the council does not make any sense.
Kita menentang keras orang yang ada kapal ini yang menghina dan mencabar kita. Saya telah berunding dengan Ketua Polis Daerah Dambangi, Tuan Zulkarnain, dan saya telah beri tempoh sehingga 9.30. Kita minta OCPD supaya naik dan hentikan segera forum ini sampai 9.30. Sekiranya forum tak dihentikan 9.30, kita akan ambil tindakan, insya-Allah.
The conundrum here is that in cases like Subhashini Saravanan, there is an overlap of the court system, something that Article 1211A had intended to avoid.
So our argument is that the facts of this case and the nature of the case actually is within Sharia court, even though it involves or it actually affects a non-Muslim, because the law, the principles applicable are all governed by Sharia principles, not civil law. That was our argument. Of course, Subhashini's counsels and solicitors were of a different view. That no, even though her husband converted, Shafi converted to Islam, and he may have a right to ask the authorities to allow him to use Islamic law on himself, but because his earlier marriage is with a Hindu wife who remains a Hindu, so the jurisdiction is with the civil court. That is where 121A was the crux of the matter in that case, to a certain extent.
Well, see, this is the other thing. Sharia courts only have jurisdiction where everyone involved in the dispute is a person professing the religion of Islam. so Muslims, someone who says he's a Muslim. So if one person is not, then actually the Sharia court has no jurisdiction. And this again has been reaffirmed in Subhashini's decision, Latif Ahmad Zain and Haji Kaha. So actually, in my view, all those spouses, when they convert to Islam, they actually had no right going to the Sharia court. Of course, because what the Sharia court does is it deals with disputes where all parties are Muslim. Unfortunately, that's my view. The federal court in Subhashini's case, what it decided, the majority 2 judges decided, is that Sharia court only has jurisdiction where everyone is a Muslim, but if you are a Muslim in that situation that you said, convert from a non-Muslim marriage, you can still go to the Sharia court, they said. But then they went on to say, whatever you get, the order you get from the Sharia court has no legal effect in the civil high court. What that means is still a little bit up in the air, and we'll have to see exactly what effect that is. But in my view, actually, that convert to Islam should go to the civil courts. The argument has always been the provision in the Law Reform Marriage and Divorce Act only allows the non-converting spouse to ask for divorce. Meaning husband and wife, husband converts, only the wife can ask for divorce. But even in some situations, there have been cases where when the husband goes to ask for divorce, even though he's a Muslim, the courts have allowed it. So it is still an option available to them. But instead, many choose to go to the Sharia court, and obviously the non-Muslim spouse cannot go to the Sharia court because, it applies Islamic law, which doesn't apply to her.
President of the Sharia Lawyers Association, Zainul Rijal, explains the conflict between civil and Sharia laws in this country.
The problem here is not the family of the convert or the non-converting parties. The problem here is the law. The law is the main problem, because Section 51 of the Law Reform Marriage and Divorce Act gives the right to the non-converting party to petition for the divorce for the non-Muslim in the civil court. Whereas for Section 46(2) of the Islamic Family Law gives the right to the converting party to petition in Sharia court. So there are two ways of doing one thing. So this is the problem. So we have been asking the government to amend the law, because it is gravely injustice to Muslim who non-Muslim who converted to Islam, because they cannot petition their divorce in the civil court. Where else should they go? They should go to Sharia court. So because this is the main problem. It's not the converting party want to avoid the obligation or whatsoever, as has been portrayed in the papers. For example, one non-Muslim couple, either husband or wife, convert to Islam. Then the non-converting party just say, no, I don't want to divorce. If the converted Muslim die, then I can enjoy the pension. I can get his EPF or whatever. Then it's not fair. So how would the converting party, the spouse, want to go ahead with the life? Maybe he wants to build up a Muslim family from after his conversion. So it is very gravely injustice to the Muslim converting party. So that is why we have been asking the government. In fact, from 1988, it was championed by Professor Ahmad Ibrahim also, to change, to amend Section 51 of the Law Reform Marriage and Divorce Act.
So Section 51 of the Law Reform Marriage and Divorce Act gives the non-converting party the right to petition for divorce. The converting party, on the other hand, would not want to go to the civil courts for divorce, and will do so in the Sharia court. But which court shall recognize which decision? This is a question that the courts have seemingly found difficult to decide on.